Hello and welcome to ThePrint. 1st of July is a very important date. This is when the three new criminal laws that will form the criminal code of the country will become effective. I'm talking about the Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita, and the Bharatiya Sakshya Adhiniyam. These laws will be replacing the laws that we have had for several decades now. This is the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act. And in fact, in the last two videos, we've tried to tell you about two of these laws, and in this video we'll be talking about the Indian Evidence Act, the new Indian Evidence Act, which is called the Bharatiya Sakshya Adhiniyam. And for this episode I have with me Supreme Court lawyer NipunSaxena. Thank you so much for joining us, Nipun.
Thank you, Apoorva.
In fact, Nipun was the one who told all of you about the new CRPC, which is the Bharatiya Nagrik Suraksha Sanhita. And in this episode, he's now back to tell us about the new Indian Evidence Act.
That's right.
Chalo, Nipun, to start
Right.
off with, just a general question to you. How much of it has changed? Because we know that there was, when these three laws were being brought about, the main narrative was that the earlier three laws were colonial and they need an upgrade. So how much of an upgrade has this specific law brought to the old Indian Evidence Act?
Very little.
Okay.
In fact, this is the least of the three tinkerings that have taken place
Okay.
in this specific legislation. But the three tinkerings which are being carried out in this act have, they assume considerable significance because they sort of dilute the distinction between what is a primary evidence and a secondary evidence when it comes to digital or electronic evidence per se.
And electronic evidence was an area where probably perhaps our laws generally maybe need an upgrade, right?
That's right.
So does this new law do it effectively? Does it give a wholesome upgrade when it comes to electronic evidence?
Well, you see, for the purposes of evidence collection, it does.
Okay.
So that's a great step forward, right? But for the purposes of admissibility of evidence, there are lots of problems.
I like that you've drawn that distinction. So let's just start with that. Tell
Right.
us about the first
first
purpose
part.
of evidence collection.
Right.
How does it address that?
So as you know, to put it very simply, a criminal trial requires collection of evidence because unless and until the prosecution can produce what you call proof beyond reasonable doubt, an accused cannot be held guilty. Right. So therefore, for the purposes of creating a cast iron case, which is every prosecutor, every investigating officer's dream, right? To have that cast iron case, they will have to collect evidence. Now, what are the different kinds of evidences? You have something which is physical evidence, right? Suppose a knife, which is the weapon of an offense, right? Or a document. Suppose there's a forgery, so you need that specific document. Or in the recent day and age, say crimes which are being committed digitally. So let's say somebody had access through gone into or hacked into somebody's cloud and had downloaded certain information which he would otherwise not have done, right? So now you need to get into the system. You might have to sort of download those images yourself or to find out whether there has been in fact a breach of their network or not, right? So for all those purposes, the kind of evidence that you are collecting also varies.
Okay.
Right? So what has happened under these laws, evidence collection has been given a very strong impetus. Okay. Let me further break it down into three different parts.
Take your time with this.
Absolutely. Yeah. So the first part is, say, witness statements. Now, hitherto under the CRPC, because what I will do for this purpose is that I will try to sort of go from CRPC and back to evidence, because collection and the way to collect evidence is all mentioned in the CRPC.
Makes sense.
Right. So under the CRPC, a witness statement under, say, section 161 or 164 was optional to have it digitally recorded.
Okay, so it was done physically,
right, in a written format, right? The IO used to have it written it down, and he was supposed to read it out back to the witness in an ideal world.
So you talk about statements to the IO as well as statements to the magistrate.
For statements to the IO, right now, right? And for magistrate, what used to happen was that it was the magistrate who used to first satisfy uh, himself as to the mental state of the person who is deposing, or whether that person or that witness is under any coercion or undue influence. And thereafter, the magistrate would record whatever he used to say word for word,
Right.
and many a times also read it back to the witness कि जो भी मैंने लिखा है, is it really what you wanted to say or not, and thereafter used to proceed, right? But central to both these ideas was the optional nature of recording through digital means. By digital means, what do we mean? By an electronic device where you are recording the conversation which is taking place, and thereafter you could see that this has been written down.
Okay.
Now, one very good thing that this particular amendments do is that they keep the systems optional still.
Okay.
Say more so for police witness statements.
Okay.
Because if you would recollect, under 161 of the CRPC and now under section 180 of the BNSS, right, these witness statements do not hold any evidentiary value when they are given to police. So you don't want one scenario where, for the purposes of CRPC, you would say that, sorry, it is written statement and the witness cannot be confronted with it. But then suddenly you take out an audio video which was recorded of that particular witness and show it to him and says, but you said X, Y, and Z. Because that would ultimately defeat the very purpose of a police statement, right? So I think that's very good, very laudable for the Evidence Act to have maintained that distinction.
Okay.
But now let's come to the second part, which is document collection, which also brings me to searches and seizure. Now, for the purposes of searches, they have made it mandatory to record evidence through digital means. Now, what will you seize and what will you search? Now, seizure could be of any particular object, document, or a thing, right? And many a times, what used to happen in trial was that there were instances and incidents where evidences were planted.
Right.
There were instances where evidences were tampered. There were instances when only police constables were the one who were witnesses, and there was no third party or a punch witness, independent witness to see the process of search or seizure. So that seizure, which was done under the old provision of 102 CRPC, was usually held to be a bad seizure in law. And the direct effect is that if it's a bad seizure, then that particular thing or a document which is collected becomes inadmissible. So here's a scenario where you have, let's say, collected a knife, but since your seizure memo was defective, therefore that collection, you can't rely on that, right? And for a prosecution, it's a nightmare. If you have the weapon of offense, but you still can't rely on that weapon of offense for the purposes of bringing home the charge. So for documents or for other things, electronic collection of evidence is a must. It has been made mandatory. What is also very interesting is that at the stage when information relating to commission of an offense is disclosed to a police officer, under the new law, if the offense is one for which the maximum term is 7 years or more, then for that purposes, an expert will be called, an expert who is other than the expert. In the sense, an outsider forensic expert will be called by the police to collect that evidence.
Acha.
So this is very interesting. It's very new and it's a very refreshing change in that sense, because I believe that the law also contemplates that with such varying degrees of heinousness of the crime, the evidence collection has to be a very serious exercise undertaken only by experts and not by police officers themselves.
And we haven't had that so far.
We never had that in our CRPC. So this is something which is, a laudable initiative. But I must also be failing in my duty if I not tell you about the practicalities of this.
Right.
The first of which is, do we really have those many forensic experts?
And this was a question that I had, that this seems to be putting a lot of pressure on those experts as well, on the entire, I mean, I think I've only seen this on TV, on in dramas that don't are not shot in India, where you have forensic experts coming in. So tell us about that. How will
Yes,
we deal with that
you are right. I
workload?
mean, so that's a logistical
Hmm,
problem.
hmm,
Practically today, do we have those kind of experts who would go and carry out those elaborate tests,
hmm.
say salt profile test or chemical analysis of the blood which is mixed in mud,
Yeah.
right? Or rather serious ones, say bone ossification
Hmm.
tests, or something like a ballistic examination. Now, all those things have to be carried out by specific different experts, each of which will go back to their own specific different laboratories to carry out and bring out their own specific results.
Hmm.
You see, so all of that will take its own sweet time.
Right.
Now, if the investigation is to be completed within a finite number of days, can you really do that?
Hmm.
And in most of the cases, there is what you call a cognitive bias, which creeps in. Say, if I am the person, I am the forensic expert who is also collecting the evidence,
Okay.
and I am the person who is also going back to the laboratory and analyzing that evidence, is it not problematic in that sense, right? Because I will always want that
Yeah.
specimen to yield the result
Hmm.
which which is consistent with my bias.
From what I understand, even right now, forensic labs in India have a lot of backlog as well. So
Absolutely. For you are right, Apoorva. I mean, for those of us who are practicing, forensic science laboratory reports are the last ones to arrive. In fact, many a times, let's forget what stage are we talking about. Many a times, charge sheets are filed, all the material witnesses are examined, prosecution rests, and of course, they make a caveat that as and when that report arrives, you may just reopen or re-examine this particular expert. But that is completely, that completely thwarts.
And that will also worsen if these experts are now not just doing lab work but also doing field work. So
Collection
it's
work,
just going to
and
get worse,
that's
right?
right. We in today's day and age, uh, we may or may not have the requisite infrastructure. So the 7-year thing that I told you about, in fact, the legislature also recognizes this and casts an obligation on the state government to issue a notification in the next 5 years.
Acha.
Now, if you were to issue a notification in the next 5 years, then what happens to the period from 1st July till the next 5 years? Who is to sort of foot the bill? Who is to bring in those expert witnesses to carry out the collection?
Right.
And it is not that crime is going to stop happening. It's only that your registration process itself will be so delayed now, thanks to rushing through these laws, that ideally, I mean, in an ideal world, when I was also talking about the previous ones, it took Indian government from 1961 to 1973, a total of 13 years, to come out with a stretch of laws. Right after 6 law commission reports gave their specific findings. This is one of those practical difficulties which are going to otherwise defeat the more laudable objective. Nobody has absolutely any problem with the objective that they seek to achieve. The problem is in the implementation, because we know in this day and age, you cannot expect an SHO working in a Dehat Thana in some very rural corner of a district to have the power to, or to requisition the services of an expert, forensic expert, to come down, travel 150 kilometers into a rural area to collect evidence.
Right.
And it is not that villages don't see murders or rapes or assaults of other kind for which the maximum imprisonment is over 7 years. So what I thought was that perhaps a little more thought would have gone a long way in ensuring its perfect implementation.
Okay, now also if you could speak a little bit about if there's any practical issue, if at all, in the audio-visual recording of search and seizure as well, or is that doable?
Well, I think there are obvious problems that one is going to face. First of all is the lack of training right now.
Okay.
Now, one might want to argue and say that, look, since these laws were already enacted sometime in December of 2023, those 6 months period, however little that short time or however short that time is, would in fact let people be trained and be ready for something. But now let's go into what exactly it is, right? So the MHA, and only yesterday, has released their handbook.
Yesterday is basically Wednesdays when they had released.
Wednesday
We're
is
shooting
when
this
they,
episode on Thursday.
all
Yeah.
right. So only on Wednesday, the Ministry of Home Affairs has released what you call as SOP for the purposes of evidence collection.
Okay. Okay.
Now that evidence collection SOP is so intricately woven so as to puzzle even trained brains like you and me.
Okay.
Let's forget about, because you see, when you are talking about implementation of these laws, we have to look at all the 731 districts in this country. We are not talking about cosmopolitan areas like Delhi, Mumbai, where we have impeccably trained, fluent English speaking investigating officers who are there at your beck and call. We are also talking about officers who are situated at very remote places, right? So now this particular SOP gives you an instance. It says, suppose you are going to search or suppose you are going to seize a weapon. What are you supposed to do? You have to go with a prescribed camera which has been made available to you. It must be 3.2 megapixel or higher.
You have to keep the camera on at all times.
At all times, you have to initiate. Before you reach the scene of crime, you must have it open. You have to go there. You have to take a landscape picture. Then you have to zoom in onto the injury. The distance must be exactly 90 degrees from the point that you are taking a picture. You have to then take out the memory card. You have to then put the memory card in a separate sealed this thing. Then you have to also take it back to your forensic guy who now should be deployed in the police thana, right? Assuming there is that guy at the police thana, then you have to ensure that once you take it out, you generate what you call a hash value of every single evidence that you have created, and then you will have to execute a certificate under section 63 of the new Bharatiya Sakshya Adhiniyam, which was corresponding to 65B certificate under the Indian Evidence Act. Now that certificate also is a two-part certificate. The first part has to be filled by the police officer who has actually carried out the search, and the second part has to be filled out by an expert, as they call it, but that expert is nobody else but the SHO of that police station itself, who has to then mirror the hash value which is generated. Now you and I today may or may not know how to generate a hash value of a specific file. Now, but the problem is that under the new law, which is section 57 of the Evidence Act itself, and we'll come more on the admissibility later, but it specifically says that even every single copy that you generate out of that particular digital device shall be a primary evidence.
Okay, and now for our viewers, I want you to differentiate between primary and secondary evidence.
Okay. Primary evidence is any evidence which is there in its original form, right? Say a memory card or a clip, right? Or a computer device from which that particular output is generated, right? Like, let's say a CPU or whatever it is. Secondary evidence is any form of evidence which is dependent on the primary evidence.
So, for example, if this is my phone, the WhatsApp chats on it are primary evidence.
That's right. But for the purposes, but what becomes secondary is, let's say if you are a police officer and you have seized this WhatsApp chat, you send it to me, right? And you forward that particular screenshot of a WhatsApp chat to me, that WhatsApp chat, the second screenshot, now under the old law was a secondary evidence.
Right.
But under the new law, now it becomes primary evidence.
What was the difference between them in terms of admissibility?
What
did primary evidence require? What did secondary evidence?
Now, for primary evidence to be there, primary evidence did not require a proof, any additional proof other than production of the primary evidence itself.
Right.
Now, in digital records, there was an exception because nobody would travel with a CPU and produce it before courts, which they did for the longest time. They used to keep computers in Malkhana and everything.
Oh, wow.
But then what they did was the IT Act had an amendment which introduced what you call 65B certificate.
Right.
Now, that 65B certificate says that you don't have to produce that original thing. What you can also do is, if you can just list its particulars and say this was the date of its opening, this was the date of its creation, modification, this is the file size, file type, etc. Under 65B subclause 4, if you were to give those particulars, then you don't need to produce the original. That certificate in lieu would be sufficient for the purposes of claiming it to be a primary evidence. But the problem is copies of those. Now, let's say if there's a screenshot and I transfer it, let's say you are one constable, I am the second constable, there's a third constable. X transfers it to Y transfers it to Z, and Z produces that chat before court. Under ideal circumstances, that is secondary evidence.
Yeah.
It's not even primary evidence, right? And secondary evidence has a very less probative value than a primary evidence. That's very important, right? It's only when primary evidence is missing that you can rely on secondary evidence. But now what this law does, and that's the first tinkering which is very problematic, is that it treats copies generated to be the same as if it was the original chat. Now, the biggest problem is that electronic evidences are most susceptible to tampering.
Which is what I wanted to come to, because Supreme Court has also in a lot of judgments spoken about this. So are the safeguards being diluted in a way?
Well, I would say that the safeguards have been turned on their head, because they have diluted the entire concept or the distinction between what is a primary evidence and a secondary evidence. Now, if you treat all the copies to be the same as the original source, then you are essentially, for the lack of a better term, institutionalizing the concept of tampering with them, right? Because today nobody can say, are we not living in a day and age where we have seen scams on Paytm, where scanners itself are sort of impose one on the other, and thereafter you pay somebody else and the money goes to somebody else. In such a day and age, if people can tamper with barcodes, they most certainly can also tamper with chats.
Also, electronic evidence and chats form a huge bulwark of the evidence that we get in courts now, right? If you look at charge sheets, they're massive charge sheets these days. Thousands of pages are just chats.
Absolutely. And the biggest problem is that Section 330 of the BNSS says that these forensic science reports, let's say, are to be produced within a period of 30 days for me to be able to dispute them. Right? Now, what happens is, which brings me to the second part, essentially, on admissibility, which is to say that earlier, if an expert witness was relying on a report, then it was given that that expert had to be cross-examined. Which is to say that the defense counsel would be given an opportunity to cross-examine that person, right?
Give us an example of an expert witness and the sort
Very
of
well.
evidence,
Say, for instance, somebody, a doctor conducts a post-mortem.
Perfect. Okay.
Right?
So
now
we knew that the doctor also had to be examined.
Because there's a post-mortem report and you need a doctor. Suppose you want to find out whether the bullet which was fired, which killed the person, was in fact fired from that gun. So then you need a ballistic examination. So with that ballistic report, the ballistic expert would also be examined. Any report which is being relied basically by the prosecution could only be received in evidence or be admissible if their expert witness had gone there and deposed. Right? That was the law earlier.
Right.
Now what happens is, Section 330 of the BNSS now introduces a proviso, which says that this is not necessary unless and until you dispute the report. Now, for a second, let me just take a step back, because this is going to be causing a lot of trouble to defense counsels.
Okay.
Every defense counsel does not only rely on the report. Many a times, many questions in trial are asked to the witness also, to the expert witness about their qualifications.
Give us like one or two examples.
Right, about their qualifications. If you claim you are a ballistic expert, have you even taken the requisite qualifications? What was your degree? How exactly, what experience do you have? Have you worked with rifles, or have you only worked with, say, bombs? How do you know about this revolver? How many such cases have you dealt with? So many questions are being asked to the expert so that that expert could come across as a credible witness. And if not, then the defense counsel could break the person.
The evidence, the report can also come across as credible.
As credible.
The moment you get the expert to not be credible, you're also then doubting.
Casting aspersions on the report itself. Because we also cannot turn a blind eye to a very sordid reality that many a times reports are not made by the people whose signatures are there, right? So the best way, because a report on the prima facie may look very good, right, but
very legit,
very legitimate, so to say, but only when you start cross-examining the expert that you come to realize whether that report was even drafted by that person or by somebody else, right? And since all these reports are carried out behind closed doors, nobody knows. So the only way in which you could sort of examine or bring out the truth, which is the hallmark of every trial, the pursuit of truth. In order to bring out that truth, the only way that you could do was to examine that person. Now you can't examine unless and until you first dispute the report. There may not be anything to dispute in the report, and yet you want to cross-examine. So that one particular provision and inclusion is going to be very, very problematic, right? Specifically for defense counsels. Although it says any of the parties may, or let's say, let me put a scenario where at the stage of prosecution they are not relying on a report, but as defense I'm relying on a particular report to say, let's say that this death was not caused by poisoning. And now I introduce a chemical analyst report to say this is not done through poisoning. Now what happens? The other side may want to cross-examine my expert witness that I want to, but if he does not dispute the report, then he can't cross-examine my and all of that is now made a subject matter of discretion of the court. So even if you have disputed, you must now file an application before the concerned court and take permission as to examining the expert witness. So what was but natural in the course of events has now become a subject matter of this particular proviso. First I have to dispute, then I have to seek leave. So how many dates are wasted? 3 dates. Again leading to delay in trial. Although the objective I can see and I can sense that the objective was to cut short the delay, only have those very relevant experts and not every experts under the sun, but this is a very important procedural safeguard which I think has been breached on account of this tinkering, right? So that's one part.
So Nipun, one last question before we ask you wrapping up question now. Just taking you back to primary and secondary evidence, I think for our viewers, I just want you to probably elaborate a little bit more on what this entails. If you could give more examples on what would be considered a primary evidence, what would be considered a secondary evidence, and the pitfalls of it.
Okay. Suppose there's a dead body and a photograph is taken by, say, a crime photographer who is present at the scene. And this, since a dead body is also there, therefore the search and seizure process is also going on simultaneously under section 105 of the Act, and they are recording it, right? Now you have two different sets of evidence. One is the recording of the photograph which shows that a dead body's picture is being taken, and second is the photograph itself. Now under the previous regime, the photograph itself was considered to be a primary evidence, right? It would be a primary evidence of taking pictures of the dead body and not of the injuries itself, right? But now under the new law, while this photograph itself, since it's a hard copy, it would be treated as a secondary evidence, whereas the electronic copy which has been taken now somehow becomes the primary evidence. And that copy could be different copies which are stored simultaneously or sequentially. Now this word sequentially is very difficult, because if, let's say, there are 5 different IOs who have changed during the course of investigation, then the copy which is retained by the 5th IO must match with the copy written by the first IO. If there is any tampering which has taken place, who would prove whether there is such tampering occasioned or not? So I think it's going to lead to those problems between secondary evidence and primary evidence in that sense.
So just wrapping up now, from what I understand, probably like I had mentioned in the beginning, maybe our laws generally have always been up for an upgrade when it comes to technology. What I want you to sum up is how well of an effort does it make to not just catch up but also have safeguards in place, which probably safeguards against the perils of technology. Because right now especially is the time when we're seeing artificial intelligence, we don't really know how to deal with that. So how well of a job does this new bill do of that? And just
Well,
summing up your thoughts, summing up as well.
I think for collection, hats off.
Okay.
But for the purposes of admissibility of evidence, big problem. Also because you see, with any technology, laws will always try to keep pace with technology because of their ever-changing nature, right? So you can't have a law which is going to be good for everything. But you are right, in this day and age of deep fakes, in this day and age of manipulation of hash values,
Right.
and expecting people to understand, because tomorrow, let's say, this very IO is going to stand the cross examination where he will have to justify these hash values and why there's a discrepancy there. God forbid there's a discrepancy, right? So this is, in very simple terms, a prosecutorial nightmare.
Okay.
And it is going to be a defense counsel's paradise.
Okay. I think that's a good segue to us ending this episode. Thank you so much for joining us, Nipun. And thank you to all our viewers watching. I hope these 3 videos, and for the other 2 videos, I'm going to add a link to those videos in the description. I hope they've been able to explain to you what these 3 new criminal laws introduce and what they entail. If you have any suggestions for us, of course, don't forget or don't shy away from putting them in the comment section. Thank you so much for watching.